File Case 16-1-0133, State of Hawaii versus Stephen Capobianco, jury trial.
Good morning. Again, the record will reflect the presence of counsel for the parties. The defendant is present, the jury is not present at this moment. What I propose to do, counsel, I did want to know if you folks had anything you wanted to say about it, is as has been represented to the court, will be concluding the evidentiary portion of this case shortly, and what I thought would make sense is to then do that in front of the jury, and then the next stage would be to proceed to the reading of instructions of law. But before we get to that point, I thought it might be an appropriate time to speak to our juror in seat number 2 and to ask him what he would or what he would like to or need to do. And that's because, one, he has a vacation schedule, and two, because he has encountered a tragic circumstance in life in the last 24 hours. So at any rate, I thought we should cover that. And then if he's going to be asked, if he's going to ask to be excused, then we could seat our second alternate. Our second alternate is the person seated in the front row. And then at that point, we could proceed to the court's reading of instructions. And of course, the parties have asked, both of you have agreed, and to ask me if you would permit, if I would permit you to begin your closing arguments tomorrow, and that seems fair. And I thought I would then just cover the schedule for the jurors of the closing arguments, just to see if that works for them. And that would be Tuesday prosecution, Wednesday defense, and then rebuttal Thursday, and the final instructions on Thursday. And then the jurors can begin their deliberations, and I'll provide the alternate jurors with an instruction. Is that acceptable, Mr. Rivera?
Yes, Your Honor.
Mr. Upple?
I find it acceptable, Your Honor. The only concern that I have is, I know how full the gallery is today, and I just, my only concern is whether that would have an impact on the colloquy with the one juror, whether that presents any, additional pressure on him in any way whatsoever. I offer the alternative of doing it in camera if it comforts him in that respect, but I just throw that up as a concern. I don't know how the court feels.
All right. As I've informed the parties, the tragic circumstance I've referred to involves the death of someone, and that has occurred actually, I believe, in the last maybe 12 hours. I believe I haven't spoken to him, but I believe he's been up most of the night. So maybe I can do that at the bench, and because I'm not sure what he's dealing with right now. All right. Okay, then sounds like we're okay, Will.
Yes, other than that concern, raising that concern, I actually agree with the court's proposed procedure.
All right. Okay, then I think we're ready for the jury. Thank you. So, Mr. Rivera, I'll be calling on you in a moment.
Okay.
When the jury comes in. Yeah. I'm sorry? I'm not. To those that may be taking video, just a reminder, we have to be absolutely sure we don't have jurors' images appearing on any of the video. Thank you so much. So when we approach the bench here with a juror, please make sure that that juror's image is not part of the recording. Thank you. Actually, we could have we could have all three. Sorry about that. Didn't mean that.
Oh,
Would you-
all of them. Sorry.
Oh, sorry about that.
I'm all up.
Yeah. The record will reflect the presence of the members of the jury. I've already placed everyone else's presence on the record. Good morning, ladies and gentlemen. And if you'd like to be seated, you may. At the present time, we're in the state's rebuttal case. Mr. Rivera.
Your Honor, the state has no further witnesses. The state rests.
All right. So, ladies and gentlemen, you've heard Mr. Rivera state that the state rests. In other words, that the state has concluded its presentation of its evidence in rebuttal. The court will also gives the opportunity to the defense to also present rebuttal evidence. Mr. Alford.
We would have no further witnesses at this time.
So defense rests as well.
Yes, sir.
All right. And of course, the defense is under no obligation to call any witnesses or produce any evidence during the course of the trial. Mr. Alford has indicated that the defense rests at this time. So, ladies and gentlemen, that means that we have concluded the presentation of evidence in this case. And so what remains is the court's reading of instructions of law and the closing arguments of the parties. So we, well, just to give you an idea of what the court has in mind here, and I'm going to need to get some input from you folks. I wanted to just share this with you. reading of the instructions we've worked on, and I'm prepared to proceed with that. Yeah, the closing arguments you can anticipate will involve significant investment of time. And so what I'm proposing to do to make sure that I've considered the requests of the attorneys, as well as creating a circumstance where you can give your undivided attention to the arguments that will be presented, and to give each side the opportunity to present these arguments. The schedule that I'm proposing would be to proceed with the prosecution's closing arguments tomorrow, asking you to come in at 9:30. We'll take care of some of the logistical things related to you folks, and then proceed with the arguments at 10 a.m. tomorrow, and the prosecution will give them the opportunity to present their closing arguments tomorrow, Tuesday, November 29th, and then give the same opportunity to the defense on Wednesday, November 30th. And then under the law, the prosecution, because the prosecution carries the burden of proof, the prosecution has the opportunity to present what's called a rebuttal argument. And I normally do not ask you to come on Thursdays, but if you are available to come on Thursday, what I propose to do is to have that occur on Thursday, December 1st during the morning. There would be a few more instructions I would have to read to you, and then you would proceed to begin your deliberations in this case. That's what I'm suggesting would, I think, create the most orderly process. But part of that is asking you to come in on a Thursday, and that may present a problem for you, and of course want to be responsive to that. On the other hand, if that doesn't create an issue, then we can follow that schedule. So I just wanted to make sure you're aware of that before we take a recess that we're about to take. And I also need to speak to one of our jurors, so I'll be doing that as well. So if you could just think about what I've just said, and in particular what I'm really asking about is Thursday, December 1. And as I say, once we've finished the rebuttal argument, and I have instructions that I'll read to you after rebuttal argument, then you'll begin your deliberations, and that will proceed on Thursday, assuming you're available. And we have packets of instructions prepared for you, and so I'll do that today. There's some 35 plus pages in length. You'll all be getting your own copy of the instructions as I read them to you. All right, so we'll take a recess at this time unless there's something else. Okay, we'll take a recess, and I'll ask if our juror in seat number 2 can remain. All right. I'm going to be asking our juror in seat number 2 actually to approach the bench. And counsel, you may approach.